Singvi, Mr. Arvind Datar, Honorable Mr. Justice Rohinton Nariman, esteemed dignitaries, honorable judges, and our friends from the bar. Thank you, and we are grateful to you for taking out time to join us for the release of the book, The Basic Structure Doctrine, The Protector of Constitutional Integrity by Justice Rohinton Nariman. I would like to invite our esteemed panel to come on the stage. Now, I would like to invite my colleagues to facilitate the dignitaries on the stage.
For everyone, actually. Sorry, it has become a bit awkward. We're coming from back side.
I would now like to invite our Head of Strategic Content Development, LexisNexis Asia, Mr. Tim Fernandez, to give the welcome note.
Honorable Mr. Justice K.V. Viswanathan, Honorable Mr. Justice A.K. Sikri, Mr. Kapil Sibal, Dr. Abhishek Manu, Mr. Arvind Datar, and our celebrated author, Mr. Justice Rohinton Nariman, judges of the Supreme Court of India, Delhi High Court, and our friends from the bar. Distinguished guests, ladies and gentlemen, good evening to all. It is my honor to extend a heartfelt welcome to each of you to the launch of the Basic Structure Doctrine, authored by the esteemed Justice Rohinton Nariman. We are privileged to have you all join us for this significant occasion. Today we gather to celebrate the release of a seminal work that delves into one of the most pivotal doctrines in India's constitutional law, the Basic Structure Doctrine. This doctrine has played a vital role in preserving the integrity and the stability of the nation's legal framework, ensuring that the fundamental principles of the Constitution remain protected and has inspired and been adopted by many other countries in their administration of the constitutional law. Justice Rohinton Nariman, a distinguished jurist and former judge of the Supreme Court, Justice brings unparalleled expertise and profound insights to this book. His meticulous research and scholarly analysis offer a comprehensive exploration of the evolution of India's constitution, focusing on the development and significance of the basic structure doctrine. The book examines key amendments, landmark cases, and judicial perspectives that have shaped the basic structure doctrine, providing a balanced view of its impact on the legal framework. The basic structure doctrine is not merely a legal principle, it is a safeguard against the erosion of constitutional values. It restrains absolute power and prevents corruption within the government organs, ensuring that the interpretation of the Constitution remains rightly with the judiciary's purview. Through his rigorous research and analysis, Justice Nariman demonstrates why this doctrine is vital for maintaining the integrity and the stability of India's constitutional framework. As we embark on this intellectual journey through the pages of the basic structure doctrine, I'm confident that this book will serve as an invaluable resource for the scholars, legal practitioners, and anyone interested in understanding the intricacies of India's constitutional law. Justice Nariman's expertise and dedication to the subject are evident in every chapter, making this work a significant contribution to the field. We, LexisNexis, as publishers, take immense pride in the fact that this publication aligns strongly with our overarching mission to advance the rule of law and shaping a just world. Thank you all for being here and for your unwavering support. We look forward to an engaging evening filled with insightful discussions and thought-provoking questions. I would now like to invite our celebrated author, Justice Rohinton Nariman, to deliver the opening address. Thank you, sir.
Good evening, all. Thank you all for being present here, especially my former brethren, honorable judges, the honorable judge sitting on stage, my very dear, dear friends on stage, all of them. Ladies and gentlemen, you couldn't have a better day to launch this book. This happens to be Dr. Ambedkar's birthday. He was born on this day in 1891, and he could justifiably be called the father of our Constitution. I must also hearken back to just one day previous. 13th April is perhaps the blackest day in our history, which we must never forget, because on that day in 1919, Reginald Dyer, a British general, took our own troops in Jallianwala Bagh and actually fired at and killed and hurt a very large number of our citizens. And that is exactly the point of this book. Can that ever occur again in free India? This time, by Dyer being replaced by one of our own generals or police captains, and doing this to our own people. Obviously, it cannot. And the reason it cannot is because, in large measure, of this great doctrine which the Supreme Court has laid down to save us from constitutional amendments which may allow such things. If I may begin at the very beginning, the very first amendment was the subject matter of challenge. The first amendment amended a number of provisions, curtailed fundamental rights, and contained one very draconian provision, 31 capital B. Now that provision essentially was like some kind of residue in the Constitution where acts which were actually struck down by the Supreme Court would get resuscitated. It's an amazing provision. I mean, when one sees it, the moment you insert, you being either parliament or the state legislatures, insert an act into what is called the ninth schedule, then not only is it protected from harm, so to speak, and what is the harm? The harm is fundamental rights being enforced by courts, all of them. Having been then so protected, it goes on to say that even if something has been struck down by a superior court, including the Supreme Court, that judgment is of no avail, and the section, act, or whatever it is, bounces back with full fury against the citizens of this country. Now, surprisingly, nobody really focused on 31B in the very first case that was heard, which was Shankari Prasad Singh Deo's case. And Patanjali Shastri Ji, who delivered judgment, said this, and said, as a matter of fact, surprisingly, the only argument raised against 31B was that it required ratification by the states, which was not done, since it affected various articles of the Constitution, including 226. And that was turned down by the bench. But then the bench went on to issue a caveat at the end saying that this appears, particularly the second part, to be overbroad. But at the moment, nobody said anything about it. We leave it at that. What Shankari Prasad Singh's case actually did was to look at Article 13, which says that the moment there is a fundamental right which is impacted, infringed, then any law made by the legislature will naturally give way to the fundamental right. But then they said that, look at 13 and then look at 368, which is the power to amend. And ordinarily, since 13 is an inclusive definition, it includes various laws and would therefore include constitutional law as well. We have to harmonize it with 368, which is the power to amend. And if we harmonize the two, then it is clear that 13 must give way to 368. Now, that was the vision for about 15 years, until finally in Sajjan Singh's case, again, the 17th Amendment got challenged. There were doubts cast on Shankari Prasad by two learned judges. And an 11-judge bench then convened, which was in the celebrated Golaknath case. Shankari Prasad's vision of Article 13 giving way to Article 368 was overturned. And therefore, in Golaknath, what was said was fundamental rights from this point onwards are sacrosanct and can't be touched, constitutional law and constitutional amendments notwithstanding. Unfortunately, the razor-thin majority in Golaknath, because that was by 6-5, also added that the power to amend is located not in Article 368, but in the residuary power of legislation, which is a little far-fetched and difficult to accept. That being the weak point of the judgment was then undone by constitutional amendments that were made in 1971, in particular the 24th Amendment. And after it was undone, Golaknath's case itself came under scrutiny. And that's how Keshavananda Bharati's bench was formed, the largest ever of 13 learned judges of the Supreme Court. It is interesting to note that of the composition, 6 senior judges were Chief Justice Sikri and Justice Shelat, both of whom belonged to the Golaknath bench, then Justice Hegde, Justice Jagan Mohan Reddy, and each of these judges, senior judges, all voted in favor of basic structure. It is only one senior judge, Justice Ray, who voted against and had been consistently voting with government in the last few cases. On the other hand, the junior judges were exactly the opposite. Those who had just been appointed post-71, and all of you remember there was an election in 1971. And what was done away with was a very healthy convention. The convention was that the Chief Justice will ask the government to appoint somebody, and unless there was an objection, that somebody got appointed. Here it was turned on its head. And what happened instead was that it's the government now who sent names to the Chief Justice and overrode the Chief Justice as well. And that happened in 2 cases specifically, in the case of Justice Beg and Justice Dwivedi, both of whom came up. So we had now an array of 6 senior judges, 5 voting for basic structure, Justice Ray standing out, and 6 junior judges 5 of whom again voted against basic structure, with only Justice A.K. Mukherjee holding out, who joined Justice Hegde. The pivot, of course, was Justice Khanna, who was the judge exactly in between. Now, this case spanned some 66 days of argument. We are told that originally the petitioners went to Mr. Chagla, who had retired by then, and asked him to argue the case. He said he was too old, and then he requested Mr. Daftari to argue the case. Mr. Daftari also demurred, and then they finally said the only man who's capable of doing this is Mr. Nani Palkhiwala, and that Mr. Chagla must use his good offices with Mr. Palkhiwala and get him to do so. Mr. Palkhiwala was not at all enthused, but then ultimately could not refuse Mr. Chagla. The result was that a couple of weeks before the hearing was scheduled, Mr. Palkhiwala was brought to Delhi. He had no notion of what he was supposed to argue. And he locked himself apparently in a room in the Oberoi. And he had a huge team with him. He never met the team. He only got notes from that team, which he asked for from time to time. And he had a couple of judgments, including the SCRs, put in his room. And he just locked himself up for about 2 weeks and prepared the case. And then when he started, apparently it was extremely difficult for him to get a word in edgeways, because all 13 judges, or at least a majority of them, started almost speaking at the same time and jumping on him. And this happened for about 2 or 3 days. Fortunately, Chief Justice Sikri met Mr. Daftari at some dinner party. And he asked Daftari, how do you think the hearing is going? So Daftari, in his inimitable style, said, it's going very well. It's a matter of fact. There was an American tourist who came in the other day. She was most impressed by these 13 wise men. And she was asking, but who was that young gentleman who kept interrupting them from time to time? Chief Justice Sikri got the message. And day 4 or 5 onwards, the thunderclouds vanished and Palkhiwala was allowed to argue. He took 31 days and spanned almost every country, certainly every continent, must have cited in n number of cases. And ultimately, when he sat down, he sprung a surprise on Sirvai, who was the Advocate General of Maharashtra, appearing for the other side, together with the learned Attorney General, who was Mr. Niran Dey. Now, there again hangs a tale, because the government of the day was very keen on Sirvai starting and not the Attorney General. And that was completely wrong. So there was animosity between the two of them, until finally it was made up thanks to a tea party in my father's chamber. My father was Additional Solicitor General at the time and hosting Sirvai to lunch throughout all this. And the animosity vanished, and then it was agreed between the two of them that Mr. Sirvai will start and Mr. Dey will be held up in some conference or the other, so that he should be allowed to start. Then when they started, they took something like 34 days, the two of them. And finally, on the 66th day, it was Palkhiwala's turn for rejoinder. And Justice Beg fell ill. Now that was one other big thing that happened, because there was a deadline, and the deadline was Chief Justice Sikri's birthday, 25th April 1973. And we had already reached March. So Justice Beg's illness prevented Palkhiwala from starting his rejoinder. And as a matter of fact, when they assembled again on 23rd March, Palkhiwala said, doesn't matter, I will forego my rejoinder, I will put in my written submissions. And finally, Justice Beg got well again, because it was in the balance as to whether Justice Beg would now actually vote, not vote, whether the case would go on, not go on. So it almost never happened. And finally, one day before Chief Justice Sikri retired, 11 judgments were handed down. Now, as soon as they were handed down, we found that the only common measure among 7 learned judges was the fact that there was something called a basic structure to our constitution. And the 7th judge, Justice Khanna, did not agree with the other 6 judges on what the other 6 judges described as implied limitations. Now, I always thought that suppose they had used the expression inherent limitation instead of implied, it would be much, much easier, therefore, to settle in a mind, because it is then easy to say that, look, you have to read the power to amend a constitution in the setting of a constitution, and you have to see the setting in all the other articles. So there are inherent limitations when you look at the pattern of government in all the other articles. That becomes much more palatable, but somehow or the other, the word inherent was never used. And implied got stuck in the throat. So implied was knocked out by 6, knocked out by Justice Khanna as well. However, as a matter of construction of the word amend or amendment, ultimately, 7 learned judges, fortunately for us, all said that amend is used in a narrow sense. They adverted to the Attorney General and Mr. Sirve's concession, which is that you cannot repeal the Constitution simpliciter. Now, if you cannot repeal the Constitution simpliciter, something has to remain. What is that something? That something can only be basic structure. So this was the kind of logic that was used. Now, close, and before we finish with Keshavananda, in fact, there's one other very interesting thing I adverted to in the book. One part of Article 31C, which I must tell you all, accords primacy of 2 directive principles over fundamental rights contained in 3 articles. One part, the last part, precluded there being even a judicial review of whether a law made by the legislature has made a declaration which is correct or not in law. Now, how do I explain myself? The declaration has to state that, look, I, the legislature, look at the directive principles contained in 39B and C, and in furtherance of those principles, I am making this law. Now, suppose the law had nothing to do with those directive principles. Even then, judicial review by courts was eschewed, it was out. So this part was struck down by 7 learned judges using the basic structure doctrine for the first time in Keshavananda itself. What is equally interesting is 4 of the minority judges out of 6 all said that this part will not obtain without giving reasons. Now, obviously, it cannot obtain only if there is a basic structure, which is the tool with which you can say it cannot obtain. But that was inconsistent with their judgment, because their judgment was there is no basic structure. And if there's no basic structure, they should have gone the way Justice Ray and Justice Palekar went, which is to say, yes, in which case constitutional amendment cannot be touched, over, end of matter. But this was the infirmity of 4 learned judges from the very start. And they are all minority judgments. Each of them says, no, that last part will not obtain. Why will it not obtain? We are not told. But anyway, they left it at that. Now, after Keshavananda's case, we had a test case in Mrs. Gandhi's own election judgment. And what was done there was truly extraordinary. She lost in the Allahabad High Court, and her appeal was pending here. When the appeal was pending, there was a 39th Constitutional Amendment Act which was passed. It was truly extraordinary. It was an Article 329 capital A consisting of 5 sub-articles. Sub-article 4, in short, only said that the appeal that is pending now of the Prime Minister and an imaginary speaker, because there was no speaker appeal pending, the appeal pending of the Prime Minister will be decided without applying any law. Truly extraordinary. And it will be allowed under Article 5 by the Supreme Court by applying subclause 4. Now, the bench which heard the case consisted of 4 minority judges in Kesavananda. Justice Khanna being the only member of the 7-judge bench majority. 4 minority judges said they were bound by Keshavananda's ratio, and each one of them used the basic structure doctrine to knock down this amazing article. Chief Justice Ray was forced to knock it down, saying, look, this offends the rule of law. It can never be that an appeal can be decided by applying no law. So on that short ground, it was struck down by him. The other judges each found some facet of basic structure to strike it down. Justice Khanna said free and fair elections, part of democracy. There has to be an election tribunal, which goes into the facts. Here, nothing is gone into. No law is applied, therefore bad. Justices Matthew and Baig both said the constituent power, whatever it is, cannot exercise judicial power without first granting judicial power to itself. And here it purports to exercise judicial power without ascertaining facts and without applying any law. So, out the amendment goes. And finally, Justice Chandrachud held that it offends Article 14, which is part of the basic structure, in that the Prime Minister and the Speaker, for no intelligible reason, has been put above everybody else who has lost an election. Now, one very interesting thing happened. In fact, two very interesting things happened after Indira Gandhi's case. One was that Sirvai, who had all along stuck in fact doggedly to his theory that there is nothing like basic structure, completely changed his mind. And he said that the difference between Indira Gandhi's case and the earlier judgments was, this was the first time basic structure was used in a non-property context. First. And second, what was considered in Kesavananda to be things which are outlandish and which can never happen have actually happened. So something outlandish has actually happened, as a result of which he changed his mind and became a great votary of basic structure thereafter. Another very interesting thing happened immediately after. The moment these judgments were delivered, within 3 days, a 13-judge bench was reconvened, this time, to say that basic structure should be revisited. Now, Chief Justice Ray reconvened the bench with a number of other junior judges who had just come in. And we are told that he kept on saying that it has been reconvened at the instant first of Mr. Palkhiwala's client, who was again brought to re-argue. And Mr. Palkhiwala said, I wouldn't be out of my mind to ask for a reconsideration of basic structure when I've succeeded on this. So the Chief Justice was put into a corner and then said, no, but then Tamil Nadu has asked for it. And to his great credit, Mr. Govind Swaminathan got up as Advocate General and said, we have done nothing of the kind, we support basic structure. And then he got further into a corner and said, very well, then the state of Gujarat has done it. And the Gujarat Advocate General got up and supported Govind Swaminathan and said, I have done nothing of the kind. So the net result was that there was a revolt then within the judges themselves, and abruptly the second day of argument, Chief Justice Ray walked into court and said, bench is dissolved. So the first attempt to undo Kesavananda failed. The second attempt was in the Constitution 42nd Amendment, where by adding 2 subclauses to Article 368, the amendment now specifically said there is nothing like basic structure and no constitution amendment can now ever be challenged in a court of law. This was struck down in the celebrated Minerva Mills case later, saying that suppose there was a procedural infirmity, not substantive. Suppose, for example, 2/3 of each House of Parliament present and voting was in fact not present and in fact not there when the amendment was passed. Or suppose it needed ratification of half the states and only 1/3 the states are ratified. Even then a court can say nothing. So for that reason it is bad, apart from any other. So the second attempt also failed. And once that second attempt failed, this doctrine has been used n number of times right till the present to strike down arbitrary and excessive constitutional amendments. I may tell you only one thing, that when Mr. Palkhiwala began his argument in the original Kesavananda Bharati case, he was desperately looking for some judgment in some jurisdiction which would, as a matter of fact, apply here by saying that an amendment can be struck down on substantive grounds also and not procedural. There wasn't a single such judgment. And all that he could rely upon was a speech given by a German professor, Dieter Konrad, from Heidelberg. And that speech became an article. And in the article, Dieter Konrad gave 4 extreme examples and said, suppose Article 21, which is the right to life and personal liberty, is removed. It can be removed by a simple majority of 2/3, no ratification needed. Is that something that one would envisage with a democratic constitution? Suppose you were to bring back Mughal rule, or you were to bring back the British king and replace this monarch with the president. Could you do such a thing? And then he said India is to be a union of states. Suppose you just do away with all the opposition state governments and say there'll be only 2 states and nothing else. And best of all, the most telling example was the 4th example, which was, suppose you were to give the power to amend to the executive. So far, Parliament had to have a 2/3 majority in each house and ratification by states. Suppose you were to remove that and say, no, give it straight away to the President of India in his executive capacity, and an executive order can do what it likes with the Constitution. Is that something that was envisaged, or was it not envisaged? So that was all that he went to the court for, with. And it is remarkable that he succeeded with only this article. Now that it has been laid down, it has been picked up by a number of other countries, which I have also adverted to in the book. So I leave now all of you with Mr. Datar, who will conduct the panel discussion for you to delve further into this doctrine. All I can say is that the endeavor of this book is that this doctrine has come to stay. It can never go. And if by chance it ever goes, God help this country, Jallianwala Bagh becomes a distinct possibility.
Exactly. I was going to say that. We don't need a discussion now. Yeah, we're ready.
Now we would request our esteemed panel to officially release the book.
I was about to release some other book. This would be like Yes Minister. In Yes Minister, the Prime Minister pulled out the wrong speech and started reading. There were 2 speeches.
Honorable judges, past and present, and distinguished members of the audience, we are running out of time, so I'll be brief, and my co-panelists. When we decided to have this book launch, I was trying to find out any particular individual who has actually heard the arguments in Kesan Bharati, which started in 1972, mid after August, and ended in March. And I was just finding, because when I did the courtroom genius with Mr. Sorabji in 2002, 2005, many of the people were still alive. And I was wondering who could be the person who could speak about the arguments if he was personally present. I know Prashant Bhushan was there for the review. And when this panel was formed, I just spoke to Mr. Kapil Sibal and I said that, were you in law college when this matter was heard? He said, I was enrolled in 1972 and I attended the entire hearing of Kesan Bharati. So we have the unique privilege of a person who has actually heard the arguments, and he says he heard the arguments in the review as well, as a lawyer who had just started his practice. So we are indeed extremely fortunate that we have Mr. Kapil Sibal, who was witness to the arguments, and he has gone down, he'll go down memory lane. So I thought we can start the panel discussion with his recollections of what actually took place in the court. And we have decided not to have speeches by all of us, but just freewheeling comments followed by a question-answer session. We'll try to keep it as light as possible, but let us start with the most important, Mr. Sibal, who was actually present in court.
I just enrolled. Good evening, everybody. I just enrolled in the bar, and I was a briefless lawyer, so I would normally go from court to court watching judges. And when I heard that this matter was on, I went to court 1. And there I saw Nani Palkewala arguing. And the one thing that struck me was that he never looked, though Rohinton says that he cited several law books, but while I was there, he hardly referred to any law books. His understanding of basic principles of law, his felicity of language, his love for literature, he just mesmerized the court by telling them the differences the differences between meanings of law and the Constitution. What does law mean? What is the Constitution? Basic principles of law he enunciated with such great clarity that anybody who was in court was just mesmerized by his forensic abilities. And quite frankly, I have also had the privilege of helping him in some cases. And what I found was that Nani never really cited the law to make the law. He, in fact, made the law by not citing the law. He had the ability to encapsulate principles of law which do not find place in any judgments. And then that's how he developed sales tax law, that's how he developed income tax law, that's how he developed constitutional law. And I remember when the review took place, he argued for a couple of hours, and he didn't look at any book. He referred to no book. He just argued for 2 hours non-stop, and nobody could ask any questions from him at that point in time. So he overpowered the court by just his presence. And he never hesitated on, when a judge would ask him a question, he would have a ready answer for it, and a very fine answer for it. So what I learned from him, and I think all lawyers, and this is what I wanted to say today, all lawyers learn that lawyers are meant to develop the law. If you start looking at judgments and start now looking at the law and say you must follow this law, you'll never be able to develop principles of law. So the one thing that we must do when we go to argue, and this is what I learned from Palkewala, and I followed it, I've followed it all my life. Look at the facts, know basic principles of law, and develop them in the context of where you want to go and where the legal, where law should be, because ultimately law is a vehicle for change, and new situations come up in the country which require change. And what Rohinton has said, and quite frankly, today the basic principles are here to stay. The basic doctrine is here to stay. Nobody can change it. In fact, Article 359 of the Constitution itself says that even in a national emergency, Article 20 and 21 will remain in force. Now, once there is a constitutional provision which says that, nobody can change the basic structure of this country. But the real challenge, and that's why I want to start to this discussion, is that you don't need to violate basic structure by changing the principles of basic structure. You can violate basic structure by bringing in ordinary law, which is contrary to the basic structure of the Constitution. And the principle laid down in Keshav Nand Bharti is that basic structure is only a concept which is applicable to the constituent power of Parliament. But if you have laws which are contrary to the basic structure, you can't challenge them on grounds of basic structure, but you can violate basic structure on a daily basis, and that's what's happening in this country.
Yeah, Can you start the mic, please?
Use this.
Yeah. Yes, can you hear me? Yes. We'll start the discussion, and I'd start with Justice Sikri. And sir, is there any particular way you'd like to describe the justification behind the basic structure doctrine? Sorry.
You take this. Here.
Yeah.
Okay.
Thank you very much. First of all, let me congratulate our very dear friend Rohinton, who has brought this book in his inimitable style, as he does always. And in 15-20 minutes, I think he has been able to describe what this book is and what the basic structure doctrine meant. Since you have asked me to describe it in my way, and going by what Kapil also said a few minutes ago, that we should not go to the precedents or the case law to advance our point, and we should try to create our own this theory about it, and it's our duty to lay down law. So I see basic structure doctrine from a different prism. And what the majority said in Keshwanand Bharti, and as Rohinton has already mentioned thereafter, it has been not only it's firmly established, and it is the view already expressed by Rohinton as well as Kapil that it is here to stay and it cannot be, and I am also of the same view, it is here to stay. But let me go just prudentially and go to the basics of it. We are a democratic country. We are a constitutional democracy. And our preamble starts with the words, we the people. So the main thing which I am emphasizing is that it is the people of India, we the people, who have given ourselves this constitution. And another very interesting attribute, or a very important, pertinent attribute of our constitution is, because there can be various kind of constitutions and even various kind of democracies. It can be, and we know of the countries where it is very limited democracy or only a formal democracy as we call it. But our constitution has given what I say, and the jurists also say, liberal democracy, because it is not only the constitution but all the attributes of constitutionalism which have to be in a constitution are prevalent there. We have, based on this, yes, fundamental rights are there. We have, which ensure that the people in this country enjoy these basic rights and basic freedoms. It is, as I always say, is based on the dignity which is to be recognized in the people of this country. And it is based on the identity also, which we have to formally give to the people of this country. Then we have directive principles of the state policy, which cast a duty on the state for better governance and better this thing. Of course, we have the elections and majority is there to rule, but then it is in the scheme of the constitution again that the majority will rule, it will govern, but it is not that it is given a carte blanche, and it can govern in any manner it wants. Again, the power of governance are also prescribed in the constitution, and every elected government has also to act only in accordance with the constitutional provisions. This we call either, it can be two expressions which can be used, that it is a matter of limited government, that government is limited by its power given under the constitution. And another attribute of it is that it is the rule of law which prevails. So in a matter, in this scheme of the constitution, and when we have a substantive democracy with constitutionalism, and we now come to Article 368, which is the power. So in a matter like this, or in a scheme like this, whether when this power was given to the parliament to amend the constitution, whether this power included the erosion of all these values which are there, and which is the bedrock of our constitution, And I again go back to this what we call social contract theory, which was developed by initially Thomas Hobbes. And when we say we the people and we have come together and we have agreed that we will vote, there will be franchise and the elections, and the government which wins will have right to elect. But that doesn't mean that we have ceded our authority, we have ceded our freedoms, and therefore these are always uncompromisable. So some of the elements which were given, or which are there in the constitution, if you look into from this angle, then the obvious conclusion would be that we the people never gave any parliament to take away the main characters of the constitution. See it from another angle. If we see Keshwananda Bharati and what Justice Khanna has also said, as far as fundamental rights are concerned, these are unamendable except the right to property, which he said on that also there may be debates, jurisprudential debates, but we are not going into that. Then secularism, fundamental rights, this democratic form of the government, judicial independence, three wings of the government and separation of powers, etc. These are the attributes of basic structure doctrine. Can there be, even if you take it when the power is there or not, have we ever visualized a country or a governance where these would be taken away? Tomorrow we don't remain the secular country, or we take away the fundamental rights, or we take away the minority rights, which are taken as the basic feature, or judicial power, which is there and which has been stated in so detailed time and again. Can we take away that power? Rohinton has already given so many examples. So therefore, according to me, this is the basic support, or this theory, which again says that Article 368, amending power is there, but that amending power does not take away and there is no such power to take away the basic rights.
Thank you, sir. Now thank you for your comments. Yes. I'll now just go to Dr. Singhi for a moment. And it's very easy now, after almost 50 years, to say, basic structure is so obvious. It's obviously the Constitution has a basic structure. But if you go back to the 72 when the matter started, and if you see the written submissions of Mr. Nirende, Mr. Sirwai, and so on, there was a really strong feeling that the power under 368 was untrammeled, uncontrolled. So I'll ask Dr. Singhvi, the argument, if you see the submission, was that to say that Article 368 doesn't have complete power. You are really questioning the will of the people. And the constant argument was that if you allow the Supreme Court to strike down a constitutional amendment, it will be anti-democratic and counter-majoritarian. These are the exact words used. What is your view? Now, of course, let's go back to 72. Because it's a wafer-thin majority. You see, in fact, I tell people that it's not 7:6, it is 6.6:6.4, because Justice Khanna went all the way, and it's just on 2 paragraphs on the essential features, the whole thing twisted. Just our entire fate is just on a few paragraphs. Dr. Singhvi.
Thank you, Arvind. Let me take 30 seconds to say that when Rohinton speaks for rights, we all listen. The world should listen and does listen. And it truly requires a path-breaking doctrine to be dealt with in a book-length treatment by a pathfinder. And Rohinton has done great service. I've seen most parts of the book to have dealt with it. It's suffused with his usual glow of analysis, historical evolution, international comparison, and above all, you saw his brutal candor. That's very important. Of course, I must add that those who in contemporary times act like ill-informed, casual, or motivated commentators on this complex subject should realize the amount of depth of knowledge they have to first garner before they can comment in a very casual fashion on this important doctrine. Having said that, Arvind, the question you asked, you're absolutely right. So what is Palkiwala and what is Keshwanand credited for? Clearly, the first official, complete, proper embedding of this doctrine in a juristic sense. But what is interesting is, and I want to bring this to your attention, the universality of the seed of thought which lies under the basic structure. It is quite incredible that the same seed of thought in different formats, without, of course, a judgment, is there from the 1920s. In 1920, you had unrelated people, a Carl Schmitt in Germany, a Hariwu in France, and even Kelsen around that time, talking of very similar concepts, but from different philosophies, different viewpoints, different locations, different ecosystems. All of them in the 20s is rich with this literature. How it then, and I'm sure it must have found its way into Konrad Dietrich through one of these writings. And then it found through the BHU lecture. Rohinton mentioned about the Chagla Daftari, but I am told it also found its way to Mr. Rao, who carried it to Mr. Nambiar, who then said, I am too old and unwell, so carry it to Mr. Palkiwala. But the point is, the universality of this crosses boundaries, crosses time phases, crosses nationalities, and ultimately what you find in Keshwanand is also at the second level in a universal theme running from Shankari through Sajjan, through Golaknath. There are only differing zigzags, but the basic seed idea is there. The other thing I want to put to you, it's a God forbid shocking thought, but I think we should spend about half a minute or a minute on that. It's quite clear now that you can't take away basic structure by a constitutional amendment. The highest you can do is a constitutional amendment. You can have a 2-line one, thou shalt have no basic structure. That will not survive. So is there a way in which you can do away with basic structure? Well, one clear way would be a referendum. Fortunately, in our country, it is now judicially held. Golaknath was very, very scathing about why no referendum. But more recently, referendum has been rejected in many judgments, including in the Jammu and Kashmir 370 case. So that one way is out. So lastly, perish the thought, the only way you can do away with basic structure is to do what Justice Ray tried, revisit Keshwananda Bharati. The last time that happened, basic structure got even more and better embedded. So I hope and trust that those kind of misadventures don't happen in the future. A quick word, we've counted in his book 9 plus 11, about 20 countries, which now follow it in some sense or the other. It is tragic, beyond words, that the inventor, the pioneer of something which 20 countries across the world give huge credit to India for, occasionally talks of backtracking on this subject, which is why I said that this is something for which India should be proud. It's a gift of India to the world jurisprudence. Thank you.
I may just tell the audience that Kesan Bharati had 6 writ petitions. It had 20 interveners, and 19 states were given notice. And as a matter of information, Dr. Singhvi's father, Dr. L.M. Singhvi, was the Advocate General for Rajasthan, who supported the argument against the basic structure, of course, at that point of time. So we've got Dr. Singhvi's father, who was involved, and Mr. Kapil Sibal, who was personally involved.
Physically there.
Yes, yes.
So he doesn't want it to be an admission of his old age. Huh? He's remarkably energetic.
That we won't ask anybody. But it's a privilege to have you, sir, because not many people had the chance of... I just heard him once in the tribunal, income tax tribunal. Anyway, coming to Justice Vishwanathan, what is your understanding of how do you take the basic structure theory? I mean, we're students when this entire thing came up, the basic structure theory. And you've been a lawyer and now a judge, so...
At the outset, let me congratulate Rohinton. 2 weeks back when Nina released her book and Justice Ramasubramaniam released it, he referred to Rohinton and said he never wanted to be called the chip of the old block. But you will permit me if I borrow the words of the late G. Ramaswamy and use the phrase that Rohinton may not be the chip of the old block, but he is the block of the old chip. In every sense of the word. And this book is only an example. I can put my hand on the heart and say that I've read most parts of it till the later portion dealing with the other jurisdictions which I've borrowed. And it's a fascinating edition. You get a feeling that Rohinton is arguing in court. It's remarkable for its chilling clarity, but what it does is that it gives you the build-up to Keshwananda. It starts with the first case, Shankari Prasad, goes on to Sajjan Singh. All that you will see it in the book. It's not my endeavor here to, go over that. But as far as the very theory is concerned, what fascinates me, Arvind, has always fascinated me is the soundness of its logic and its strength in its jurisprudential soundness. If I were to write something like this, I'll have the joy that a lawyer would have on the evening of his arguments if he had found an unanswerable point to the case. That it has endured for so long, and it's, unless you come out with a strong theory to oppose it, which none of the critics have as yet come forward to, the theory is here to stay. And you will appreciate the effect of the theory only if you see the illustrations that Rohinton gives in the concluding chapter of the book. He takes off from Dieter Conrad's two illustrations about what happens if, there's an amendment about the country being now told that you will only have Hindustan and one other state.
Tamil Nadu.
And
That's what Dieter Conrad says. Can be only Tamil Nadu and rest of
he
India.
now develops that and says, if all this were stopped, it's because of the basic structure theory. And the first application of the doctrine came in the Indira Gandhi case, which he dealt with. And if you think of the
Original article.
nature of the amendment, that an election can't be called in question in a court of law and a pending appeal will abet. And all the judges who had hitherto, who had daggers drawn with that theory, came around and said, no, we can't have any of this. And the strength of the basic structure theory will be best appreciated if you view it with the illustrations that are given, that have been neatly tabulated in the book. Justice Singhvi, Mr. Singhvi raised a point on
Not yet.
a referendum. If you refer to Rohinton's earlier book, The Discordant Notes, he refers to a question by Justice Palekar to Palkiwala. And I thought that was what Rohinton called the most difficult question which Palkiwala encountered in the entire hearing. And the question was, Mr. Palkiwala, you are advocating this theory of basic structure. Would you do this if 368 in its original form had always provided for a referendum? In which case, then you are really not against the amendment being proscribed or basic structure, being a theory which is to be implemented, but you are on the procedure that is prescribed now because it's Parliament which amends with appropriate ratifications in given cases. But if it were a referendum, could it amend the basic structure? And Rohinton says that Palkiwala had difficulty answering. But today, with 368 in the form that is in, it cannot be substituted with any other form. And in my view, even if it were to be a referendum, since certain fundamental rights are natural inhering rights, they cannot be taken away. They are put behind the hands of the majority. And if fundamental rights are the limitation on even the legislative power, and today, even in a referendum, it could not be taken away. But that's out of question now. So the strength of the basic structure can be best appreciated if you illustrate them with concrete examples, and it's a very sound theory. The other argument which came closest to challenging it was by Justice Kanyalal Mishra. I read this in Rohinton's father's book, that one of the reasonings given by many of the judges who adopted the basic structure doctrine was that Article 368 used the phrase, the Constitution will stand amended. So ultimately there has to be something which will remain, which will stand amended. It can't be that you can repeal the Constitution in entirety. And equally so, you can't remove the basic structure. So it appears Mr. Kanyailal Mishra countered this by saying, could the draftsman have said the constitution will sit amended? It's only a manner of expression that it stand amended, and he was trying to belittle the argument. But I think, but for this, if you see the critics which you have highlighted in the note that you circulated to us, none of them even come close to offering a possible alternative, which would safeguard the constitutional values and then, leave an enduring impression. So in that sense, the theory is here to stay. But having said this, I must also end on a lighter note, that it appears Keshwananda Bharati, who was the head of the Ilanir Mutt, his case was chosen first by Mr. M.K. Nambiar because he thought if a mutt challenges it, it will have a better impact. But Keshwananda Bharati himself had no clue of what the challenge was. And the joke is that every evening, 6 o'clock, when the All India radio would have the news bulletin for 68 days, that today the Supreme Court heard arguments in the Keshwananda Bharati case, he would send for his attendant and ask, what's going on? Why is my name coming in the radio every day? This is a story circulating in Kanjangad. But every case leaves a history. And so when Keshwananda Bharati passed away a couple of years back, and the press asked me, I said, he may not have known about the significance of the case, but his contribution is so vast. Just as England have erected a statue for Donoghue in Scotland, after the famous Donoghue versus Stevenson case, it's time we at least have a portrait or a statue for Keshwananda. So I once again congratulate you. I would request each one of you to read the book. It's a remarkable treatise. It gives you the background, it gives you the argument, some of the fascinating points raised. Justice Matthew, who was in the minority, most of the judges said fundamental rights are conferred and they don't inhere. Justice Matthew's conscience wouldn't permit that. He said no, it's a natural right. But then how do you permit that to be amended? He invoked a salus populi suprema lex doctrine. He said it will cede to public interest. So he considered that it was a natural right which inhered. Constitution only recognized it, but he said it will cede to a higher right. Even the minority opinions are fascinating. The process, the thought process, the reasoning, it will inspire any lawyer. It certainly inspires me as a judge. It certainly inspired retired judges. So congratulate you, Rohinton, once again. At the bar, he kept raising the bar. As a judge, he led the way. The problem is he's not keeping quiet even after retirement. So I wish the book all success. I wish Rohinton many more books to his pen. And thank you very much for coming over this evening.
Thank you. Just wanted to also tell the audience, you mentioned about Justice Matthew's dissent. In fact, I was rereading the judgment, and those of you interested, in para 1692 of the judgment, Justice Matthew says that the right to freedom of speech is the matrix upon which all the freedoms are founded, and nobody can deny that freedom of speech is an essential feature of the Constitution. He says so, but he says it is amendable and therefore it can be taken away.
Larger.
Yeah, larger. Mr. Sibal, you are the party in person in the audience, but could you say some few words about basic structure before I throw it for question answers?
Yeah, the thing is, you talked about referendum, but you must remember that in the 45th Constitutional Amendment in 1977,
Bill by Shanti Bhushan.
Bill in Shanti Bhushan brought, this was exactly what the bill said, that if there was to be a referendum, right, and that referendum said that the theory of basic structure doesn't exist, right, that unfortunately for us, that also was not passed. It fell in the Rajya Sabha. So this attempt was made. Yes. I just wanted to point that out, that referendum theory really did not pass muster. But I want to suggest another point of view here, which is that no power and no exercise of power is limitless. Recently you saw a judgment of Justice Pardiwala and Mahadevan when they ruled that, look, the governor has to decide within a time frame. So when you look at the Constitution and the articles of the Constitution, you will find that there is, if you were to interpret the Constitution, the inherent inhibition in the exercise of absolute power actually is found in the Constitution itself and its various articles. So the basic structure theory did not say anything more than that. And I wonder, even if they had held that there is no basic structure of the Constitution, a time would have come when in the exercise of power, courts must have realized that there is no absolute exercise of power, and there are inherent limitations in that. And you will find that in each article of the Constitution. So I imagine that at any given point in time, this basic structure theory would have come about through judgments of the court of law, despite the epochal judgment that was rendered at that point in time.
Yeah, Dr. Singh, sorry.
That's number one. That's number one. Number two, and my worry now for the future, and I said that in my opening remarks, that there are several legislations today that are operating. If you were to, through an exercise of constituent power, pass that amend the Constitution, it would be contrary to the basic structure. But outside the Constitution, they already are violating the basic structure. You see that they are violating federalism. They are violating the secular fabric of this country through existing legislations. Now, you can't challenge those legislations on the ground that it violates the basic structure. You have to have them struck down by virtue of Article 13, because they violate Part 3 of the Constitution. That the courts are not willing to do. So the result is that despite the fact that the basic structure doctrine has gone away, yet the fact is that it is being violated on a daily basis through existing legislations where the courts are not striking them down. And that's my greatest worry. And the last point I want to make is that this is a tour de force. This book is a tour de force. I don't think anybody other than Rohinton Nariman could have written this book with this clarity, with this depth of knowledge, with his perspicacity, and his understanding of the essential principles of constitutional law. So hats off to you, Rohinton.
Thank you.
Thank you.
Just a couple of minutes. By the way, Keshavananda Bharati, a few years before his death, gave an interview where he complained that he had never visited Delhi during those 66 days and never seen or met Palkhiwala, his main lawyer. But 2 points. One is, conceptually and philosophically, what is basic structure? And it's important to repeat that to ourselves. It is a recognition, ultimately, of all these things we talk about every day. It's a recognition that power corrupts and absolute power corrupts absolutely. It's a recognition that many, if not all, dictatorships are constitutional dictatorships. We tend to forget that. It is a recognition that anti-majoritarianism is part of the bulwark of constitutional rights. If majorities could do everything, there'd be no need for constitutions. And the other thing which follows the basic structure is that, yes, in theory, the Constitution is supreme, and within the Constitution, the basic structure is supreme. But the gatekeepers and the interpreters of the Constitution, and therefore of the basic structure, will remain judges. So now we know who is supreme. They are the gatekeepers, they are the interpreters. And I think that's something which we have to not cavil about, because that is an area where we put our trust in an institution, which will ultimately, by interpretation, make some mistakes sometimes, but will ultimately defend that bulwark of freedom.
The Constitution is supreme.
Constitution is supreme, is the biggest, one of the fictions we're talking about.
That's the most dangerous thing to say that the Constitution, because you interpret.
No, that's the point. I'm saying the gatekeepers,
But then
the
there has
gatekeepers and
to be some
interpreters.
institution which has to
That's
do
right.
that job.
That's exactly
And
the point
It
I'm
can't be other
making.
than the judiciary.
That's exactly the point.
I have been at pains to point out in this book more than once that the Constitution trusts only 5 learned judges of the Supreme Court to interpret it. And that is Article 145(3).
Yes.
Yes. And the second point was, apropos the practical aspect of which Kapil commented on, that this is an important legal issue which some constitution bench or 7-judge or 9-judge bench should decide. There appears to be a line of thinking, as Arvind and I discussed, that ordinary laws cannot be struck down on the ground of basic structure. Only constitutional amendments can be struck down. It is taken supposedly from some words of Justice Matthew in Indira Gandhi.
It's a one-off.
Those
And it's wrong.
Justice Matthew's words are probably seen out of context, been followed unfortunately in other judgments, including Kuldeep Nair and Anjum Qadri, etc. The result is that a very large mass of things which can actually destroy very many aspects of the basic structure are unchallengeable unless they are constitutional. This area must be legally revisited. And Justice Matthew's comments in Indira Gandhi Nehru don't really go all the way. They are being picked up by later judgments to suggest so.
Yes. Now, we just, the program says question and answers for 5 minutes. Anybody has any Q&A? Yes. I would request, because we're running out of time, just only the question, no comments, just the questions, please. Yes. Yeah, I can pass on the mic, yeah.
No, it was not working. No?
He was very generous with this mic because it doesn't work.
Congratulations, Justice Rohinton. In today's digital age, where India has already begun its journey towards becoming a cognitive colony, where Indians have begun to start vomiting data on a daily basis, where we are more relying upon chat GPTs and AI rather than our cognitive freedom, can we actually say that my right to digital sovereignty, my right to cyber autonomy, my right to digitally vomit data, my right against cognitive colonialism be read as an integral part of the basic structure of the Constitution, and would it really warrant any subsequent recognition by the courts of protection? Thanks.
I think this is the next PIL now. Yes. Anybody else? Any other question? No, it's an important point, but I don't know what ultimately freedom of speech and the yes. Yes, please. There. You can. If you want any particular panelist to answer, you can ask.
I will just concern rather, because independence of judiciary is an integral part of basic structure. But when Parliament negates the judgment of the Supreme Court, and we have recently Election Commission case, and we have the Delhi Civil Servant case, and that goes on, and recently we have the Governor's judgment, Supreme Court judgment. If that is negated by Parliament, by law, then there is a threat to the judicial, this doctrine of basic structure. That is my concern. Thank you.
Yeah. Yes, please. And that's the last.
Sir, I wanted to ask Justice Nariman, by not allowing ordinary legislation like a Representation of People's Act in Kuldeep Nair case to be tested on the grounds of basic structure, is that not a danger that federalism was affected by those amendments? Or, for example, under PMLA, you have those draconian provisions which are difficult to challenge. This judgment has said in that UP Madrasa case that if you allow ordinary laws to be challenged, then it is a great danger that you give the leeway to the high courts, and it may not lead to any coherent jurisprudence on that.
First and foremost, as I pointed out in the book, basic structure is not an extraterrestrial concept. It lies in the actual wording of the articles of the Constitution. So, if you wish to challenge an ordinary legislation, look at the ordinary wordings of any article. Don't call it basic structure, but if it offends any article, that is itself a superior law, get it struck down on that front. So my answer, therefore, would be that there are many articles which may pertain to basic structure, may not pertain to basic structure. But every single article of the Constitution is above ordinary law. And if you test it, therefore, against any article of the Constitution, whether it pertains to basic structure or not, and if it falls foul of that article, it will fall foul.
May I just respond? Yeah. See, the problem lies here. If it's not exercise of constituent power, it's exercise of ordinary law, then under Article 13, if it violates Part 3, it can be struck down. But you have a Supreme Court that doesn't strike it down. If you had the same law passed through a constitutional amendment, it would be struck down, as it would be violative of basic structure. But the ordinary legislation, which is contrary to basic structure, is upheld by court. Supposing we were to pass a law saying that no particular monument will be demolished, let's assume, right, of a particular community, it will be struck down. But if the ordinary law says that you can do it, that's not violative of basic structure. So there's a real problem that I think our country is going to face.
But then the question would be, as rightly mentioned by Justice Rohinton Nariman, we'll have to look into the text of the Constitution, that whether it violates any other provisions of the Constitution.
But it is upheld, supposing it is upheld.
Here minority rights are there. I mean, it's the Constitution.
The way out is to change your judges.
No, but this is a conundrum that comes up and will come up in times to come.
Yeah, I'll just make my short comment on this basic structure and ordinary laws. I've always, as a student, I've always thought it paradoxical that you can strike a constitutional amendment as violative of basic structure but not an ordinary law.
Correct.
If basic structure means the essential features, in African countries and in Pakistan they call it structural pillars. If these are the essential features, like say for example separation of powers, where is it mentioned anywhere in the Constitution? But if you got a matter where suppose tomorrow, we gave the example in the Madras Bar case, suppose it say because there's too many check bouncing cases, we put it to a banking tribunal consisting of some 2 retired general managers and they can sentence a man to jail also. That's a banking law, but I dare say it will be struck down because if separation of powers has been held to be violation of basic structure, an ordinary law can be struck down is my humble view.
That's a debate that we want.
And ironically, Chief Justice Beg in state of Karnataka was Union of India. I was reading the law.
Correct, one off.
Yes, there are comments which say cannot be. Justice Keher in the National Tax Tribunal, Justice Beg in this particular thing, has said that you can, ironically, that you can strike down an ordinary law also on ground of the basic structure. In fact, Justice Matthew's observation is more like an obiter. There is no plus and minus. He simply says it can't be. Why not? Nobody
he doesn't
says.
explain
So
that.
my humble view is that tomorrow if a matter comes before the High Court or the Supreme Court and if it's violating basic structure as enumerated by the Supreme Court, even an ordinary law can't pass muster. Okay.
Much less an ordinary law. Passing.
Yes, you're right.
Thanks. Now my pleasant duty to make the closing remarks. Thank you all for coming, and I must tell all of you that this is an absolutely fabulous book. What I liked about the book was that Justice Nariman has taken the trouble of taking the minority judgment. You see, we keep on saying Keshan Bharati, Justice Khanna and basic structure, but nobody bothers to see what are the minority views. If it was 7:6, there must be a very strong ground. And as Justice Vishwanathan said, the judgments of Justice Palekar, Justice Matthew, Justice Chandrachud, extremely closely reasoned and very, very compelling reasons not to accept basic structure. And one must put ourselves in a time machine and see those times when they thought. And it is ironical that all of them said that we can't imagine any parliament doing something outlandish, as Justice Nariman said. And it's a strange irony that within a few years after basic structure, you had the 39th Amendment, which exactly did what people said could never have been done. The beauty of this book is that he has taken the minority views and then given his comments as to why it is not correct. The other important thing I say, those of you who buy this book, please make a note, please go to page 302 of this book. And it is an irony that Justice Saqib Nisar of the Pakistan Supreme Court has made a table, it's amazing, where he has made like an Excel sheet, all the cases from Keshan Bharati, Indira Gandhi, Minerva Mills, Vaman Rao, Sampath Kumar, Samba Murthy, and he has highlighted which are the points of basic structure and which judge said what. So this is really a remarkable thing which Justice Nariman has taken the trouble of finding out. And he has also mentioned how the law has developed in various countries. Those of you interested, perhaps the best book on this is Yaniv Roznai's book, Unconstitutional Constitutional Amendments, where he has studied 700 constitutions from past thing, and then he goes into various cases where the basic structure has been adopted.
He also commends Keshwan and the Bharati.
Yes. And he says India is the forerunner. Singapore and Pakistan, Singapore and Sri Lanka have not accepted it because their constitution permits complete abrogation of the constitution itself. And I just mentioned one thing because I was involved in writing this Courtroom Genius with Mr. Sorabji, and I had the benefit of doing large number of interviews, including late Justice Y.V. Chandrachud. And I'll just mention a story that Kesan Bharati may not have been necessary if Palkhiwala, that's what, there's a very famous solicitor from Bombay called D.M. Popat. Yes, of Mullah and Mullah. Sajjan Singh was being taken up. And mind you, in Kesan Bharati, like in Sajjan Singh, it is just not His Holiness Kesan Bharati. The second petitioner is Raghunath Rao Ganpat Singh and a Nawab. And there are other petitioners who are sugar mills and mining mills and so on. So they also were actually in the litigation. Similarly, in Sajjan Singh, there were a large number of industrial companies which were involved. Sajjan Singh had challenged the 17th Amendment, where at one stroke, 44 laws were put into the basic, into 9th schedule, and it was completely held unchallengeable. Just for a passing moment, Nariman makes a very compelling reason that if 31B itself is violative of basic structure, because you can't have such a situation. Anyway, so coming back to Sajjan Singh, Palkhiwala was briefed for 3 sugar companies to appear, and he hated to wait. So he told Popat that when the matter is coming up, I'll come and argue the point. And in the discussion, he mentions it in Gujarati. And what they were discussing, Popat and Palkhiwala and others, were that, look, if you say amend, can they take away freedom of speech? Can they take away 21? These were the actual questions. So he says that, is there some line beyond which the parliament cannot cross? So he said, well, let's put this point to the Supreme Court. He was going to argue the next day, but Justice Gajendra Gadkar said, arguments are over, we are not going to wait for anybody, and the arguments closed. So one of the ifs of history was, if he had been there, because it was 3:2, Sajjan Singh. So one argument, if Palkhiwala was there, maybe it would have been 2:3, and Kesan Bharati may not have been necessary. But that's just one of the histories of this thing. Other thing I'll mention is Dieter Conrad's article. I managed to get a copy of the original article, which is underlined by Palkhiwala. And if anybody is interested, please tell me, I'll mail it to you. And in this article, which is underlined by Palkhiwala himself, as Justice Nariman mentioned, it's an article written in 1966, delivered, I think it was Banaras Hindu University. He had lectured in Banaras University. And he makes a very important point. He has seen the 1965. Just after the Sajjan's 17th Amendment. He makes a very interesting observation. He says out of 17 amendments, 5 are for political reasons, state reorganization and so on and so forth. But he said the very surprising thing of the Indian system is that almost every amendment is to overturn a Supreme Court judgment. And he says that destroys the trust in your system. So he makes a very strong observation that if every judgment is going to be overruled by an amendment, then it's not healthy for the rule of law. And of course, the other point meant. But it's a very, very compelling article, which is worth reading. And it's almost deja vu, like what he expects what to happen. And he concludes by saying, I hope that India will have a brighter future and so on and so forth. So this is as far as Conrad is concerned. Friends, we've had a wonderful evening. And I would definitely say that this has added a great deal to the scholarship of basic structure doctrine. Is something which we should not forget. And I'll conclude by saying that the main criticism of basic structure is that it is anti-democratic and counter-majoritarian. I'll only submit in my own view is that the purpose of basic structure is not anti-democratic and counter-majoritarian. It's actually to protect democracy from a majority. Thank you.